Hello, my name is Michael Tesoro and I prepared this presentation entitled ASIC and MUFs MAF Waiver case, and I'll be looking at the case ASIC and Commonwealth Bank of Australia, which came down from the Federal Court at the end of 2022. And for those who don't know what MUFs means, it is actually a sort of bungling something or doing something in a clumsy manner. So I think in this particular case, ASIC muffed the MAF Waiver case by the way it presented its case to the court. Bit of background about myself: I'm a competition and consumer lawyer, and I've been running my own practice for the last 15 years, and I help companies in competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as Director of Enforcement. Now, the background to the outline of the presentation, I'll start with some background, then look at Justice Downes's decision, and then finish with some commentary. And there's a definition of muff. It's defined as a bungling performance or to act or do something clumsily. Now, the conduct occurred over a pretty lengthy period of time from 2010 to 2019 and involved CBA charging a monthly account fee, or a MAF, between $4 to $6 to certain customers in circumstances where the customer was entitled contractually to a waiver of that fee. Now, the overcharge occurred on at least 7 million occasions and affected almost 1 million customers and occurred over 800,000 accounts. And the judge noted that during the relevant period, CBA had set up 14.8 million relevant accounts. So I guess she's comparing the number of accounts affected by the alleged illegal conduct with the total number of accounts that were opened. And she notes that in the relevant accounts, it applied the waiver of the MAF correctly on 610 million occasions. So again, comparing 7 million with 610 million. And CBA received $48 million revenue from this improper charging of the MAF and commenced a remediation program which, as at the 13th of September 2021, had refunded $64 million to customers, obviously the amount overcharged plus interest. Now, the ASIC had three primary contentions. The first was the charging notification case. So it alleged that on each occasion that CBA notified the customer that a MAF had been charged on its account, on their account statement, it made an implied representation to the customer that it had a contractual entitlement to charge the MAF, and it alleged that this was misleading or deceptive conduct in contravention of 12DA of the ASIC Act, and also that this was a false or misleading representation about the existence or effect of a condition, right, or remedy. So two breaches of the ASIC Act on each occasion that the MAF was improperly charged. The second contention was the systems of process case, and this was again on each occasion that CBA entered into a varied contract with customers. It made an implied representation that it would have adequate systems and processes in place to ensure that MAF waivers were applied appropriately, and also that it did not have reasonable grounds for making a future representation that its systems were appropriate. And ASIC alleged that that constituted a variety of breaches of the ASIC Act, as well as a contravention of the Corporations Act. The final contention was the fairness and efficiency case, and this focused on 912A of the Corporations Act, and the three elements to this contention. The first was that by charging MAFs to customers who were eligible for a waiver, it had breached its obligations as a licensee to perform its duties in a fair and efficient manner. By continuing to maintain systems and processes which were not capable of ensuring compliance with obligations, it also breached that obligation. And finally, by failing to undertake an appropriate review of the multiple systemic issues or failures that had arisen, it breached its licensing or its license duties. Now, the first thing ASIC sought to do was rely on some alleged admissions by the CBA that it did not have adequate systems, and it referred to responses in notices and said that they were admissions, but realistically they were very vague and not specific at all. As you can see, Justice Downes comments that what does the statement appropriate even mean? Against what standard are the compliance measures being compared? Is what CBA considers to be appropriate the same as what ASIC contends is adequate. On what facts is his opinion based? Do these facts align with ASIC's case? So she concluded that even if it was admissible, no weight could be attached to this purported admission without knowing the answer to these questions. She decided it wasn't admissible anyway, but had it been admissible, it wouldn't have been given any weight. She also looked at the customer's understanding, and this is where ASIC claimed that the customer would have expected the system to be perfect, whereas the judge's view was that the class of customers who entered into contracts with CBA would not have had that expectation. Rather, most customers would have had an expectation that banks make mistakes, that they are aware that there is at least some prospect of computer systems malfunctioning, software design errors occurring, or simply human error in data inputting. So again, there was a difference of opinion between the judge and ASIC as to what the expectations of consumers would be. Then ASIC pointed to a number of cases and claimed of authority that bound the judge. The one I've referred to here is ASIC and Australia and New Zealand Bank, ANZ Bank, and here was Justice Alsop. But the key difference between the current case and the ANZ case was that ANZ continued to charge various fees after it became aware that it had no authority to do so. So an error was identified and the conduct continued. And that is the significant difference between the CBA case, the ANZ case, and there was also a case against NAB where they discovered a problem, were aware of the problem, and continued to charge various fees to consumers. And actually in the NAB case, which I'll probably cover at a later date, Derrington found that the conduct of NAB was unconscionable. But here there was no evidence that CBA discovered the problem and continued charging or not providing the waivers. Then there were some other cases which ASIC pointed to and claimed that they were authorities, but really they were agreed settlements where facts had been agreed with the other party, and accordingly they were no authority for any principles that could be binding Justice Downes to a particular decision. So she rejected all those other cases on the basis they were agreed settlements. Now, in relation to the charging representation case, a really key issue was that CBA had given customers a warning. So when customers got their account statements, there was a clear note on the first page saying to customers that they should check their entries to make sure they were correct and let the bank know immediately if there are any errors. So here people are being put on notice that the system is not perfect and there could be mistakes. And then, as she said there, the very same document that it is alleged conveyed an implied representation that the entries were correct expressly put consumers on notice that their account statement may contain errors, incorrect entries or erroneous entries. So you can't just pick out part of the implied representation. You have to look at the representation in its entirety. So the conclusion that the judge reached in relation to the charging representation case was that ASIC had failed to establish that there had been an implied representation to the customer, as alleged by ASIC, that CBA had not made implied representation that a contractual entitlement to charge the MAF, and that it was entitled to depart from its contractual promise that it would not charge a MAF. There was no implied representation made by by the CBA. So accordingly, ASIC's case under the charging representation contentions or allegations failed. The second contention was the system and process case, and here the judge again pointed to the warning that was provided to customers about the possibility of errors. So here what the CBA said, that it accepts that sometimes we can get things wrong, and when this happens we're determined to make them right. So this expressed acknowledgement that errors may be made negated the existence of the alleged implied representation. As stated by Justice Downes, one does not impliedly represent an existing and future ability to perform a contract perfectly, but at the same time expressly acknowledge the possibility of an error in that performance. So you've got to look at the entire representation. You can't just pick and choose. So the conclusion in relation to the systems and process case was that ASIC failed to establish their case, that the ASIC had conveyed an implied representation that it had and that it would have adequate systems and processes in place to ensure that it could provide the MAF waivers. So it didn't make that representation. But even if the representation had been conveyed, she concluded that it was not misleading and deceptive because it did not have the capacity to induce error. And this is having regard to the characteristics of customers who fully understand that errors are likely to occur, that there's no system that is absolutely perfect. So in the systems and process case, the judge concluded that ASIC had failed to establish any of the contraventions via the ASIC Act or the Corporations Act. Now, turning to the fairness and efficiency case, the first point that the judge noted here was that the way the provision works is to look at the steps taken by a licensee to achieve compliance with the statutory norm. So what systems do they set up to ensure there's no problems? You do that before you look at any specific instance of non-compliance. And then the fact that there were problems subsequently, clearly here there were a lot of problems, did not necessarily mean that the systems which CBA had set up were inadequate. So you're really looking at the systems set up and whether they were set up in a way that met the obligation to provide services efficiently, honestly and fairly. Now, the big issue here was how was the judge to determine whether CBA systems were adequate or not. And here she noticed that she was looking at submissions made by ASIC which were entirely unassisted by any expert evidence or evidence of any relevant comparator. So ASIC hadn't gone and got expert evidence explaining what an adequate system was, or looked at the systems of competing banks and then compared that to the CBA. And as she says there, a failure to apply a waiver properly at one point in time does not tell you what it is about CBA systems and processes which is not adequate or capable. And so she's saying you can't just look at the errors and say the system was not adequate. You have to have some evidence against which to compare the system and to conclude that it falls short. So that was a significant failing in the evidence presented to the judge. She would have liked to see a comparator or expert evidence explaining what an adequate system looked like. So she says that even though there were 7 million occasions on which the MAF was erroneously charged, this had to be seen in the context of 610 million occasions when it was correctly applied. So as she said there, the occasions on which CBA wrongly charged the MAF represented a very small percentage of the total number of transactions. And in effect, the number of mistakes was approximately 1% of the total number of transactions. So as she notes there at the end, CBA systems and processes for providing specific MAF waivers were not infallible. No systems are, but they operate as intended almost all of the time. So she concluded that ASIC did not establish its case in relation to Section 912A of the Corporations Act. So the decision was that the requirement to establish a system that never made a mistake, that always applied the waiver correctly, was not required under the legislation. And had the legislature expected such a high standard of licensees, then they would have included that in the legislation. So the fact that it wasn't included in there, banks and licensees have to implement perfect systems, therefore it could not be expected for CBA to have such a system. Now, just a bit of commentary about the case. As I suggested earlier, I think ASIC muffed this case up. I guess the first thing is they've argued implied representations, and they're claiming that particular representations are going to be understood by consumers a certain way. And here I think the judge is probably correct that consumers would not understand the representations the same way that ASIC claimed. Customers expect there to be errors in various systems, particularly big systems that banks use. So again, they're relying on implied representation, which is not made out on the way customers approach these particular issues. Also, it appears that ASIC ignored that the representations were conditional or had a disclaimer. They weren't simply saying that here's your statement, all the transactions are going to be correct. They're specifically pointing out to consumers that there are errors that do occur from time to time, and that customers have an obligation to check their statements to make sure they're all correct. So you can't ignore part of the representation that's being made to consumers. You need to look at the whole representation, and if you look at the whole representation, then the possibility of errors is clearly being brought to the customer's attention. Therefore, the other concern is that they relied on all these other cases which clearly weren't authority. You've got to look at the principle established by the case and then point to it as being authority. And it's clear that those other cases, both the ANZ case and the NAB case, turned on the banks discovering a problem and then continuing to improperly levy various charges and fees. This wasn't the case in relation to CBA. It's really wasting the court's time by saying cases are authority when the fundamental principle is different. Furthermore, pointing to agreed settlements as authority is really wasting everybody's time, because they're not authority for any legal principles. It's an agreed settlement which the judge has considered and approved, but they can't be relied as authority. So again, this seems a strange approach for ASIC to take. Clearly, putting forward an argument to the court without any expert evidence or a comparator system was a mistake, something the judge would have placed some weight on by the sounds of it. And really, you've got to be putting evidence forward to explain what an appropriate system is. If you don't put that forward, the judge has no way of knowing the system isn't appropriate. And so that was a big failing by ASIC. I think what made even more concerning was that the respondents, CBA, was writing to ASIC prior to the trial, saying that there's a problem with the allegation that the system is inadequate. You haven't particularised it in any way. So they've been put on notice that this is a concern. It's clearly going to be a big issue at trial. And yet, despite being put on notice of this concern by CBA, ASIC didn't take any action to provide better particulars, to find a comparator, to obtain expert evidence. And that's a mistake. You can't just ignore what the other side's saying about the flaws in your case. You've really got to take that on board, and particularly here where it's been found to be a legitimate concern. There was also a part of the trial where the judge pressed counsel for ASIC as to what their submission was about how the system should operate, and in those submissions the barrister for ASIC claimed that their submission was the system had to work 100% of the time. It had to be perfect. Now that obviously set a very high bar for ASIC, which it was never going to meet, and I don't think if that was the right submission to make. Really, by setting a submission forward that the system had to work 100% of the time, they were just setting themselves up for failure. It should have been a different submission made. Now clearly the submission that I think should have been made is, here you have a system that has failed 7 million times. It's impacted almost 1 million consumers. It's had an impact on 800,000 accounts. It's gone on for 9 years and it's reaped the bank $48 million in extra revenue. Those factors alone suggest that the system is inadequate. Clearly saying it's 1% of the number of transactions makes it seem very minor. But if you're putting to the court that this has impacted 1 million consumers, it's gone on for 9 years, and it's generated profits that the bank wasn't entitled to of $48 million, it's not looking so minor anymore. So it seemed to me that making a submission that the system had to work 100% of the time was an error, and furthermore not emphasising these other factors and saying a system that allows such large and long-term errors to occur is clearly not an adequate system. A final issue I'll probably mention here is that I don't know why ASIC takes these particular cases, because here there was no apparent consumer detriment going forward, given that CBA had launched this remediation program which had repaid consumers, most consumers, the money that they'd improperly charged and given them interest. So $64 million of remediation had been paid to consumers. And so you're wondering what the point of taking the case is. Maybe you'll get a big penalty if you're successful, but really there's no consumer detriment going forward. And I think that's a big factor if you're deciding as a regulator to take a case, whether there is consumer detriment that you're trying to remedy. So that's all I had in relation to this case. I think ASIC didn't do a great job, and they really need to focus in on how they're running their litigation a lot better. And here, the fundamental question is whether they should have taken the case at all. But once they decided to take it, you've got to run it better than they did. You've got to be focusing in on the evidence that needs to be put before the judge to give them an opportunity to find in your favour. So that's all I had. If you have any questions about this presentation, feel free to give me a call or send me an email. Bye-bye.